All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning. We are here today for oral argument in case number CVJV21 0225, Navajo Nation versus DCS BP. Each side has 20 minutes for argument. The appellant may reserve some time for rebuttal. I would just ask that you keep track of that yourself. Hopefully there's still a clock over there. On the podium, the proceedings are being recorded, audio, video. Please introduce yourself and your client. We've read the briefs. We're familiar with the arguments, and we've conferenced the case. If you can keep that in mind when you're arguing, that'd be great. And with that, you may proceed. Counsel.
May it please the Court, my name is Wouter Zwart and I represent the Navajo Nation. I would like to reserve 5 minutes for rebuttal. Unless this Court wants me to address a jurisdiction issue, which we briefed, I will start with the merits. This appeal is about a juvenile court's failure to properly balance ICWA's presumption in favor of the Navajo relatives. This Court has stated that ICWA provides minimum federal standards on state courts because there is no resource more vital to the continued existence and integrity of Indian tribes and their children. Similarly, ICWA is based on the fundamental assumption that Indian's child's best interest that its relationship to its tribe be protected because there is extensive evidence of the detrimental impact when children are placed outside of their culture. Here, the juvenile court's vague and confusing order falls far short of this core ICWA principle.
Counsel, let me ask you a question separate and apart. Would you agree that even in ICWA cases, the child's best interest controls?
Correct, but ICWA provides a framework to balance those best interests in, and the presumption is that the best interest to be with the tribe, with the nation.
Okay, but just looking at that first issue, you'd agree that, and then I guess what Alma S says, that it's the stability and security of the child that matter. You would agree that that also applies in? Correct.
That's the court's looking at that in balance with the culture and the long-term impacts of being removed from the culture. And that's an important part of the equation, which the nation's position is the juvenile court didn't adequately balance that harm from being removed from the culture.
So, and let me ask, I think 625 days elapsed between the time that the child was removed and the tribe offered an ICWA compliant placement. Is that accurate?
Correct, because during the first case plan was reunification of the mother, and while the Navajo Nation wanted the child to remain close to the mother, to have access, and the nation was looking for ICWA placements in the area, and when DCS changed the case plan to termination, that's when the nation notified DCS that it was looking for an ICWA placement elsewhere. The Navajo's plan was never to have the foster family take it for adoption. They were always looking for an ICWA placement, so when the case plan changed to termination, the nation started looking elsewhere for placements for adoption.
So, but you couldn't find, the tribe couldn't find an ICWA placement for over 600 days. Is that accurate?
Yeah.
Okay.
Yes.
Continue.
And I'd also the nation would like to emphasize that the guidelines quote say that good cause is meant to be a limited exception. And to placement preferences rather than a broad category. And our position is that here just a bare showing of bonding kind of swallows a whole entire good cause framework. And we're arguing that...
What makes it a bare showing? To get rid of the word bare, what other facts would we add here?
Essentially, in the normal course of a child BP staying with the foster family for 2 years, it's great that you're taking care of a child and they're providing care, and bonding is in that sense normal, but it's actually unclear here if the juvenile court actually relied on bonding. It never really mentioned bonding in its analysis. It only really discussed regression. And it's unclear what regression implied, if that's just an indication of how strong the bond was, or if that meant something, one of the factors, which is the special the special needs of the child. And there's no evidence in the record whatsoever that BP required any special treatments that the Olivers, the Navajo relatives, could provide. So there's no, and the court is required to balance the bonding with the presumption that an ICWA placement is in the best interest of the child. And there's no discussion of how the court weighed the bonding, if it did discuss bonding, because it just mentions regression with the presumption in favor of that.
But would it only be supportable if the child has special needs? That the case that you cite suggests that would be a time for an exception where but I'm hard pressed to say that that's a bright line rule. If you're suggesting that it's a balancing by the Superior Court, don't we owe deference to the Superior Court's balancing?
Correct, Mr. Katani. There is a balancing and there is deference to how the juvenile court balances those factors, but there's no discussion about how it weighs those factors or how it's balanced. And the special needs and the extraordinary special needs is typically if they have like specific psychiatric or therapy needs that they have in a hospital or a therapy situation, if they're placed in a different state or on the reservation where those needs can't be met, then is a factor to weigh strongly in favor of keeping the child where it is.
But isn't that just one of the 5 guidelines? And it seems like that the BIA has come forward with to help define the undefined good cause.
Correct.
And case after case after case, at least that I've seen, has said that one, it's a non-exhaustive list, but it's also not every factor is applied in every case. So if that's the 3rd factor, or is it the 4th factor? Why is it, I guess, of dispositive significance here?
Well, the guidelines say it should start with those 5 factors, and the guidelines also say good cause is meant to be a limited exception. So when the court deviates from those 5 factors, there has to be extraordinary circumstances. Otherwise, these exceptions start swallowing the rule. Then these 5 factors have no meaning, and that's what the BIA really wants courts to look at and to start with. And once you're not starting with that, it should really be extraordinary circumstances. And the court can consider bonding, but it has to be extraordinary. There has to be something more than just...
Does it matter, or should it weigh into our analysis that the Navajo Nation initially agreed that there was good cause to depart from an ICWA-compliant placement when the case plan was reunification? So there was good cause from the outset, and presumably that meant the court would have been considering all those factors, and you would agree there was good cause at that point.
Yeah, because the case looked very different when the plan was reunified. Because ICWA's goal is to keep the mom and the child together. That's really what ICWA wants to do, and that's what the nation was doing. So as long as DCS is saying that's what we're trying to do, the nation was like, okay, we want to foster that relationship, so the child should stay close to mom. But when the case changed determination, that's when the analysis shifts, and when the nation told the DCS in February, hey, we have this ICWA-compliant placement, and these are family, these are like their aunt and uncle on their ICWA, DCS had an affirmative obligation to start fostering that relationship. So even though that we can concede...
And they attempted to, right? I mean, they started doing the video meetings between the Indian placement and the child, correct?
Sorry, can you restate that question?
They started doing the video meetings between the proposed placement with the child.
Correct, but that didn't happen.
And it didn't go well, did it?
So,
it didn't go well.
It didn't go well, but it didn't start until after the tribe had intervened. DCS was actively fighting. The record states that...
Hold on, I don't want to get into a fight on fault, excuse me. I want to ask you, when they started doing the attempt to transition, it didn't go well.
So the only testimony that didn't go well was from mother, and also the same time...
We're going through a credibility determination by the Superior Court. Correct. Is there any evidence that it was going beautifully?
From the Olivers, from the Navajo relatives, and at the same time the child was meeting with mother, and when the securities threatened, when mother's meetings went poorly, the child would have those same symptoms. And I agree that there's deference to, we're not asking you to reweigh the credibility or what happened. Well, the nation's position is that ICWA was violated in February 2020, and bonding shouldn't be considered from that point forward. And if the court balances, the juvenile court looks at the bonding beforehand.
I want to make sure I understand exactly what you just said. If we determine that somebody is at fault it overcomes the best interests of the child if the court determines that the best interest of the child is to remain in the non-Indian foster placement.
Sorry, can you say that one more time?
Sure.
Sorry.
You're saying that if there's fault, DCS fault on not complying with ICWA, that overcomes the best interest of the child.
Not quite. The regulations say that bonding shouldn't be the sole factor. So de-emphasizes the foster family shouldn't benefit from DCS's noncompliance and from protracted litigation. So the nation's position is to de-emphasize that bonding that occurred during that period of violation. Yes, Your Honor.
Go ahead, I'm sorry. Are you finished with?
Yeah.
I was just, you had said the only evidence was from the mother, but wasn't it also on the video conferencing not going well? Wasn't there also an expert witness, Mastikin, who said it should stop? And then someone else saying Whitworth, a clinical therapist, and they all sort of shared that same opinion?
So the nation's position is that the juvenile court improperly considered Mastikian's testimony because he only met the child for a very short amount of time, and he didn't meet the Olivers, he didn't really have a firm grasp of the thing. So the nation raised Rule 702 during the hearings and has briefed this throughout its briefs on appeal.
That's not an issue before us, though, which leaves us with more of a credibility assessment.
Which issue is it before?
You're saying they should not have considered his testimony at all, is that?
Yeah, the nation raised that issue during the evidentiary hearing and raised it on appeal as well.
Doesn't it go to the, I realize that you've argued that in your briefs, but doesn't that go to the weight of the evidence and not its admissibility?
Well, 702 is a gatekeeping rule, and the nation's position is that the juvenile court improperly considered Mastikian's testimony because he didn't have enough interaction with the child, and he admitted he's no ICWA expert, so he's incapable of balancing the best interests of this child if he has no background in ICWA, and he admitted he had no knowledge of Navajo Nation or culture or ICWA in the testimony.
The focus of his testimony was whether this is compliant with ICWA or not, as opposed to just this is how it's affecting the child? What does his knowledge of ICWA have to do with it?
Well, the ICWA asks for a balance of harms, and part of that harm is being removed from the culture, and if Mastikian can't conceptualize what that harm looks like for the child, and he admits this during his testimony, he can't properly balance these harms. And he can only talk to his expertise as a child psychologist, but if he can't balance those harms properly, his testimony isn't really that helpful.
Didn't Mastikian, didn't he say that if the adoptive parents, the non-ICWA placement, had not, or they weren't willing to continue the child's connection with the Navajo Nation, his opinion would have been much different, meaning he might have said that there is no good cause and this child needs to go to Ohio?
Correct, and it actually goes to one of our points, is that the nation it takes issue with juvenile court's reliance on the continued cultural exposure for the child. The juvenile court's supposed to look at, and this court's supposed to look at the prevailing social and cultural standards of the Indian community, and there's no clear and convincing evidence that mother would continue to expose a child. The juvenile court even admitted...
I understand that, and I think that's a good point to move to, but I just want to focus first on the point that Mastikian considered the Navajo heritage to be of dispositive significance, didn't he?
To the fact that...
In his opinion, that there was good cause.
Well, he weighed the foster placement's exposure to BP to Navajo culture. That's what he was weighing. He was looking at, they're taking him, they're doing some minimal YouTube videos for him to expose him, and for him that was enough.
Well, I don't know if it's minimal, YouTube or what, but you were just having a conversation with Judge Katani about, this is just a child psychologist with no care for the survival of the Navajo people, when really he seemed to be...
Our position is not that he has no care for it. He admitted that he supports ICWA standards, but our point is he can't understand the cultural harms without actually being an expert in it. Just because he he cares for the principle doesn't mean he can understand it. And our position is he can't understand it because he has no expertise to weigh those harms.
Couldn't the nation have called their own expert?
We called there's undisputed testimony from Smith, who's a qualified expert, that BP would suffer harm if he was removed from his culture. And our position is that
But the admission of the nation's expert, and that's where I was going with all of this, doesn't necessarily mean that we exclude the testimony from the other expert who can talk about his opinion as it relates to psychological damage to this child.
I think the nation's fundamental point is that if you look at the juvenile court's order, it's really hard to determine what evidence it's relying on. There's no discussion of case law, rules, regulations in the analysis, and there's no discussion of balancing, there's no discussion of, it's just reciting evidence and then coming to conclusions. That's not analysis. There's something very lacking, and it's very hard for this court or the nation to tell what evidence it's relying on, how it's weighing that, how it's weighing bonding. So nation's position, the order is just fundamentally flawed, and there's no good cause in that record to rectify that.
So I don't want to take from your whatever you want to hold back, but let's talk about the evidence. We had experts, right? And I understand 702, but the experts, there were two of them that the gal called, and they had the same opinion. And then what about the child's response to the visits? Is that evidence?
Yes.
Okay. What about the CASA report that the child must stay or should stay, needs to stay with the non-ICWA parent? Is that evidence?
Yes, Your Honor. Our position, there's no balancing of, there's no discussion of how the evidence is weighed with relation to each other. And it's not just a presumption of evidence, it's a clear and convincing evidentiary standard. And that record
for us, it's reason, right. I mean, you know well what the standard is for us, what we're looking for, and the discretion that we give to the trial court. And so is there reasonable evidence? Is there evidence in the record?
Well, the nation's position is it has to be clear and convincing, and I understand there's deference to the credibility and how the evidence is weighed, but there's still the discussion of how it's weighed, and the court has to start with a presumption in favor of the Navajo relatives, and in the analysis, there's no presumption. It's just a discussion of here's some evidence, there's some evidence, conclusion. There's no analysis bridging that gap.
So I don't have the minute entry in front of me, but doesn't the court say the burden is clear and convincing, and we start with a presumption under ICWA?
Correct, and the court's presumed to know the law, and the court stated the standard, but if you look at the analysis, it doesn't factor. Just regurgitating what the standard is without actually applying it, it doesn't actually mean anything. That's just a pro forma.
Hold on, I'm a little confused. So you're saying that because the judge didn't say, on balance, I find, that we have to send it back?
Well, I think the guardian ad litem raised Alexander K., and it was easy for this court to affirm the district court there because there was a clear discussion of how the harms will be balanced and how that happened, and it doesn't happen here. The nation can't tell what grounds the court relied on. There's no discussion explicitly of any of the 5 factors. Regression is not one of those factors, and the nation's position is that the mother's preferences are negated because her rights were terminated, and the cultural exposure is, the court admitted there's many reasons why that wouldn't happen. So it's unclear what it relied on. It seems maybe regression, but regression isn't a special needs, and if that implies bonding, it's hard for the nation to determine what's actually happening.
Doesn't regression go to exactly how strong the bond is?
Potentially, but it's unclear from the order if that's what the court meant.
What else could we possibly conclude, though? That was the whole focus of it. And because there was good cause initially for that placement, it seems pretty clear that, okay, because the placement has been it's been there for this period of time, that it would be very harmful to the child to now remove it.
In that sense, the exception for bonding to start swallowing the whole entire ICWA principle, why we should apply ICWA. If any time there's some showing of bonding between a foster placement and a child, which should happen, it's great. It's a wonderful thing when it happens, but foster care works because children can transition, and Ms. Dickey also testified that the child, if the right plan, could transition. So if all it is...
There is some point, 4 years down the road, and different children, after hearing from their reactions, that a court could reach a conclusion that in this particular case, this would be particularly traumatic, and so that.
But there's no evidence, the regression is only in the past he regressed. The court made no finding he would regress. There's no future indication. And I'd like to reserve my last minute, but there's no indication that the child would regress. The court only said he did regress in the past, but there's no conclusion he would regress. And Alexander K., if you look at it, there's an explicit finding that the child would regress, would be traumatically harmed. We don't have that here.
Okay, I have one question, but I'll get you.
Okay, thank you. Thank you.
Okay, thank you. Counsel.
Good morning. Erica Padish-Hobing on behalf of Balthazar, the minor in this case. May it please the court. The trial court conducted a 5-day evidentiary hearing and found clear and convincing evidence that there was good cause shown for deviation from the preferred placement of ICWA. They held it was in Balthazar's best interest to reside with his non-Indian, non-relative foster parents, the Jovics. The evidence and testimony presented to the trial court confirm the child has developed a significant bond with the Jovics and will experience immense trauma if he were to be displaced, given his heart-wrenching history of childhood trauma as well. The trial court also determined the Jovics, with whom he had been with for now over 3 years, have and will continue to ensure that the child is engulfed in his cultural Navajo traditions as much as possible, including...
Let me ask you, it seems like your colleague might argue that there's a built-in reverse presumption that will work against the tribe, given that time is required to move from removal to termination, and human beings bond in that period. What do you say to that?
Yes, well, good cause was put into the statute to allow for trial courts to have some deviation from the stringent 5 factors. And in the final rules, they explained that in certain circumstances, there's extraordinary circumstances that would take the child out of the normal bonding and into a more concrete, substantial bond. So that's one avenue where it's not quite as...
But is there any indication that this is an unusual case? Wouldn't any child under these circumstances would experience some degree of trauma with the change in placement? And if that can be the basis for saying we don't need an ICWA-compliant placement, it seems like it does swallow the rule that the preference should be for an ICWA-compliant placement.
Yes, I understand that. Bonding is significant here because the child came from a substantial childhood trauma, and also subsequent adjustment with the Jovic family took time. The Navajo Nation claims the trial court erred because it failed to hold the guardian ad litem to the required burden of proof in reaching its conclusions. However, the trial court specifically stated in its ruling the burden of proof, and it found good cause for deviating here. The trial court recognized in its ruling that the regulation prohibits certain types of bonding to be considered when an ICWA non-compliant placement occurs and ordinary bonding occurs in that time spent with the non-preferred placement.
I want to go back to the question that Judge Catani asked, because I think it is the crux of the case, and that is, and I'm going to use a hypothetical, which means I know it's not this case.
Okay.
So you have a department that does absolutely nothing to push forward the ICWA requirements. And because of that, and over a long period of time, the child bonds with a non-Indian placement, non-Indian foster. Where do we accommodate fault in determining what is the best interest and how it compares to the best interest of the child? Because the more at fault the department may be, it may result in longer times in non-Indian placement, which would increase the bond. And if we have a well-bonded child who now has been in foster care for a long period of time, how can the nation ever overcome that?
The court addressed that exact scenario in Alexandria. The court held that the bonding evaluation or the bonding should only be considered when ICWA was not violated. So if the initial ICWA requirements, such as the notification to the Navajo Nation when DCS took custody of the child, if DCS didn't do that, then no bonding is to be considered solely the reason for.
But now the nation in this case is arguing that there is fault because of the ICPC, correct?
Correct, yes.
And didn't it take an extraordinarily long amount of time for the ICPC to get worked out so that you could start with this transition period with the Indian placement?
Well, Your Honor, I don't represent DCS.
I know you don't, but you're representing you're trying to defend the order of the court, and this is
Yes.
part of that order.
And given that time lapse from February 2020, when the family was identified as a possible placement, it's also important to consider that it's well known that the COVID pandemic hit this country, this economy in March of 2020, which presumably slowed down some inner workings behind departments and life in general for everyone.
And so it was the February 26th that the nation found the placement?
Yes.
Okay. And as they submitted the ICPC in August, is that right?
Yes, they did, yes. And then the family was approved formally in October of 2020. So beginning in 2020, if we assume that that's when the violation occurred, the child still, even given if the child's placement was in violation in February of 2020, the child had still been there for 15 months. And the bonding should still be considered at that point. Regardless of when the timer began on the alleged placement, again, the bonding between Balthazar and the Jovics was substantial at that point. There's play therapy testimony that recognizes
and Counselor,
this.
your client wouldn't be arguing what you're arguing if, let's say, the nation had come in earlier, closer to, within 625 days of removal, and said, we are going to take the child and place him with an ICWA placement.
We wouldn't be in this position. The trial court didn't have facts, it wasn't presented with evidence of the position that you're describing. But what did happen was the nation and DCS worked diligently, the testimony provided, that they worked since the initial placement to find an ICWA compliant family, and they were not able to, get them formally approved until October of 2020.
But what if it had just been 3 months and there's excellent bonding with the child? Wouldn't your position essentially swallow the rule there that there's bonding and you can consider bonding because the nation was notified? At that point, as long as there's bonding with a foster family, that we hope happens in every case, wouldn't that mean ICWA would never result in the child being removed?
The court cannot and has not found a hard and fast time frame where bonding moves from normal to substantial, or when a child would be truly harmed from displacing them. What the biggest concern here is, and I think we can all agree we're on the same page, the nation, DCS, the court, that we want the best interest for this child to be met, and we want him to be happy and thriving in a home. So with that consideration, I believe 3 months, I haven't seen any case law where 3 months has been considered substantial enough on its own to keep the child with the non-ICWA compliant placement. I think given a totality of circumstances in each case, that's what should be considered.
What about the court's consideration of mother's continued involvement or the foster parent's willingness to work with her? Is there anything that requires that once at this point going forward?
There's nothing that requires it, but the court did find that as a positive for Balthazar, because not only does he establish more of a bond with another family member, but she's a link to the Navajo community here in Arizona, and the court looked to that factor as very substantial. She has a good relationship with the Jovics. They question her regarding traditions, and simple things like how to cut his hair in the Navajo tradition. It is healthy. Even Ms. Smith from the Navajo Nation testified that this is a healthy bond. So that is a consideration that the court took. Dr. Mastikin conducted the bonding and best interest assessment and concluded the child had a difficult time trusting and bonding at first, but is now comfortable and well adjusted with the Jovics. He testified that it could be harmful to move the child and not in his best interest, and he explained how harmful separation would be to the child's development. He too witnessed the strong bond that Balthazar had with the Jovics, more than a normal bond, and he went so far as to recommend all visits with the Olivers be suspended if this distressing behavior continues.
But to focus in on Judge Catani's question, under the law, when we're looking at this good cause, balancing, overcoming, is one element the willingness of a non-ICWA placement to keep the child connected to the heritage?
Not one element. It's not one element that should be
Is it one of the
considered.
5 BIA guidelines?
It's not one of the 5 BIA guidelines. It's supposed to be considered separate from that.
And so what, is there anywhere that says we can go beyond, or the trial court here could have gone beyond that? The 5?
Yes, and that's in the final rules that the court said, that the Supreme Court has held. It's a very persuasive authority in guiding courts in making determinations with ICWA, and it's a very substantial authority to be used, and that goes beyond the 5 factors. It says that they're not the only things that need to be considered. Also, ICWA says they should be. It doesn't say they must be. The Jovics have and will continue to engage the Navajo traditions for the child. They don't just talk about it, they actually put their words into action. He currently takes Navajo language classes. He's able to visit the
That could stop next week if you win.
Your Honor, the trial court can only base its decision on the facts that are presented at the time. So on the facts before it, at the time it made it ruling, and the facts before Your Honors at this point, based on that, there's no evidence that it's going to discontinue. He visits, like I was saying, he was able to visit the Navajo land here in Arizona. He wouldn't be able to do that in Ohio. Again, his biological mother's relationship is substantial, and he reads Navajo children's books and watches children's educational TV shows. In sum, the trial court was correct to find by clear and convincing evidence a good cause was shown to deviate from the preferred placement. Even if this was a normal child, to take him away from the family who's raised him nearly half his life, his biological mother, his home, his school, his friends, the Navajo community here, and move him nearly 2,000 miles away would be extremely difficult. Balthazar's finally settled, adjusting to life, and forming deep bonds with family members in the Navajo community. To displace him now from these comforts to a family he barely knows would utterly disrupt his life and undeniably lead to developmental regression. The trial court heard from Dr. Mastikin and Ms. Smith that this would be a possibility, and likely would happen based on his current behaviors. The purpose of ICWA is ultimately to ensure the child's best interests are met. The legislative history of ICWA states explicitly the use of the term good cause was designed to provide state courts flexibility in determining the placement of an Indian child. In balancing the harm of displacing this child or deviating from the preferred placement, the Navajo Nation cannot show the court abused its discretion by denying their motion.
Thank you, counsel.
Thank you.
Mr. Zwart.
I have a few quick responses. First, there is no evidence that BP would suffer trauma. There's no evidence to record that there's a future certainty that he would suffer that. And there's something extraordinary, as Judge Catani pointed out, that disbonding threatens to swallow the whole rule, and that's, I think, what we'd like to point out.
Can I ask you one question on your Rule 702 argument? You're saying there is a basis for us saying under no circumstances should Dr. Mastikian have testified, and it doesn't just go to the weight of his credibility because he's not a particular expert in in tribal issues?
Rule 702 is a gatekeeping function, and the nation there's not sufficient data and exposure. He only had a 30-minute meeting with BP to base his whole entire analysis on. That's just not sufficient.
Doesn't it go to the weight of his testimony as opposed to, he seems like a qualified expert otherwise. That just goes by into how much time he spent with parties and
I think we addressed some of that in our briefing, so I would point the court to that. I see my time's up, but I just want to emphasize. Go ahead.
I have one question. Can't the nation tickle 3 months or 4 months after removal that, well, there's a bond forming between a non-equal placement, and so you could protect your own interests 6 months, a year and a half? I mean, couldn't the nation have come in here and put this child, and I don't think there would have been any argument, in an equal placement earlier on?
Correct. If there's, I think first there has to be equal families. There's not always, the nation, everyone looked very hard for a case early on, but the point is the case plan was reunification mother, and it made sense to put it in a foster placement that wasn't adoptive. There was no potential for adoption. It was put child back with mom, and that's ICWA's goal, and that's what everyone's focusing on. And when that changed, kind of this whole case kind of changed. So when everyone's just trying to get back to mom. And I think
your final point, I'm sorry.
Yeah. But thank you for your time, and we'd just like to point out that we don't want bonding to swallow the rule. And I think Alexander K. is an extreme example. If you look factually, we put a lot of emphasis in distinguishing that case where the court considered bonding, and it was one factor among many. And bonding there happened 5 years after placement. ICWA didn't apply for many years until the proceedings, so there's a very different case than here. So even though the court did consider bonding, it's not at all like this case here. So we'd like to end with that, and thank you for your time.
Thank you, and thank you both for your arguments today. It's much appreciated, and we will take it under advisement and have a decision in due course. We adjourn.